All right, and I do not have a written opinion. I have my notes to give an opinion. Frankly, I would have probably preferred, well, not probably, would have preferred to have more time to write a more well-written scholarly opinion with the actual cites to cases, but I know that both sides would rather have the case resolved today. And so I'll try to be as clear as possible, so either side may pursue any remedies you see fit. And I won't give citations to the cases, but I'll refer to them by the names that were used in your briefs, and so you'll know which case I'm talking about. In this case, the defendant, Anuja Rajendra, is charged with violating the Michigan statute that makes it a misdemeanor for a person running for political office to advertise or use in any campaign material the words incumbent, re-elect, re-election, or, and I quote, otherwise indicate, represent, or give the impression that, unquote, the candidate is the incumbent when he or she is not. And the statute is MCL 168.944. Specifically, the prosecutor's office charges in the complaint and in their brief that Ms. Rajendra violated that statute by giving the impression that she was an incumbent senator, and they base that on the statements in the complaint that she allegedly made in a campaign mailer. In the first charge, count 1, quote, as your state senator, I am steadfast in my commitment to, end quote. And the second misdemeanor charge, count 2, for the statement, quote, as a mom of 4 and as your state senator, I want my kids and all kids in Michigan to have the same opportunity for quality education and success, unquote. Those statements are alleged to have misled the voters by giving them the impression that Ms. Rajendra was an incumbent senator when in fact she was not. And that is the theory in the People's Brief, pages 1 and 3, and in the complaint. There is no claim and no one's arguing that at any time Ms. Rajendra used the words that are prescribed in that statute. She never referred to herself as an incumbent or used the words re-elect or re-election. The defense argues that the statute is unconstitutional on its face, pursuant to law from the U.S. Supreme Court, specifically the Alvarez case, in which the U.S. Supreme Court found that statements made by Mr. Alvarez, who falsely claimed he had earned the Congressional Medal of Honor when he did not, that it was deliberately and knowingly made and false, that nevertheless his speech was protected by the First Amendment. The defense also cites other cases from the Sixth Circuit Court of Appeals and Ohio to support their position that even false political speech is protected by the Constitution. The prosecution relies on the only Michigan appellate case that appears to address the statute under which Ms. Rajendra is charged. That is the Lostraco case, 150 Michigan, a 1986 case from the Michigan Court of Appeals. However, in that case, it was a judicial campaign in which a district judge running for circuit judge used language that could be read to look as if he were the incumbent circuit judge, the position for which he was running. His opponent had gone to circuit court to get an injunction to stop him from using that language in his signs, circulars, and advertisements, and wanted him to have language that specifically informed the voters that he was a district court judge. But even in Lostraco, the Court of Appeals acknowledged that both state and federal law regarding free speech in the political arena provide great protection for speech concerning the public. However, the court there concluded that since the circuit court found that the judge's materials and wording were in fact misleading, any further publication of them would constitute a knowing misrepresentation. And so enjoining them would not therefore infringe on the defendant's right of free speech. The premise on which the Lostraco case is decided lies on the point, as they state, quote, knowing misrepresentations are not constitutionally protected free speech. And in my opinion, that has been overruled or at least clarified by the U.S. Supreme Court case in the 2012 Alvarez case. The defense also referred all of us to a series of cases from Ohio, the Magda decision from 2016 in particular, where the Ohio courts faced a very similar situation as I see this one, where a lower court decision had said that like Lustraco, that false speech merits no constitutional protection. And when they ruled on it and looked at it based on Alvarez and other decisions, they found that the Ohio statute was unconstitutional. Even if the statements made in the campaign literature of Ms. Rajendra are false, and of course the defense claims some may read them as aspirational, especially in their context, but even if they were false, the US Supreme Court has made clear that the highest protection is given to political speech, and the appropriate remedy to false political speech is more political speech, not restricting such speech. And for that, I will cite to the Alvarez decision, 567 US at 727. Since the statute under which Ms. Rajendra is being prosecuted is a content-based restriction on the exercise of pure political speech, it is presumptively invalid and subject to strict scrutiny. Such statutes may only be justified if the government proves that they are narrowly tailored to serve a compelling state interest. And for that, I refer you to the Reed case. In this case, Mr. Shea argued today that there is no reason for this statute, that there was not a compelling state interest addressed here. But even assuming there is, and it could be preserving the integrity of elections and protecting voters from confusion, the law under which Ms. Rajendra is being prosecuted does not protect those interests. It is not narrowly tailored. Far too much legitimate, clearly protected speech we want to hear during campaigns is restricted or chilled. As the Sixth Circuit Court of Appeals stated in the 2016 case that the prosecutor cited and filed last night, Winter v. Woltnitzek, they cite a US Supreme Court case, Brown, to say, and I quote, "Erroneous statement is inevitable in free debate, and the chilling effect of absolute accountability for factual misstatements is in the course of political debate is incompatible with an atmosphere of free discussion." The statements for which Ms. Rajendra is criminally charged could easily have been addressed and debunked by counter speech to correct any potential misunderstanding. Prosecuting her after the election does nothing to correct any misleading statement to voters because the election is over. Post-election prosecution not only fails to address the claimed compelling need and issue, it can punish citizens running for office and deter other well-qualified people from running. I find that the statute is both over-inclusive and unconstitutionally vague. It fails to give fair notice of what conduct is prohibited. The statute prohibits speech that, quote, gives the impression of incumbency. What does that mean? The defense in their brief gives an example or asks a question, what if there were a picture of the candidate outside the state capitol building in an ad for literature? Does that suggest she's the incumbent? Interpretations may vary. Courts warn that the government should not be the one to decide without standards. It could lead to arbitrary and discriminatory enforcement. And let me make clear that I'm in no way suggesting that that is the case here, but it is a concern expressed by appellate courts ruling on First Amendment issues such as these. So in short, I find that the statute under which Ms. Rajendra is charged is unconstitutional on its face and as applied. It is not narrowly tailored to further a compelling government interest. It prohibits speech without providing fair notice of what speech is actually prohibited. And I am well aware, that as a district court judge, my ruling has zero precedential value beyond this case, but I am granting the defense motion and dismissing the charges against Ms. Rajendra with prejudice.